Well, I've been misinformed then, but that's irrelevant. Thank you. Councillor Reid, you have a question?
Thank you, too, if I may, Chair. Could you just clarify the ownership of what I would say is 50% of the drive that leads down to the road? Whose ownership is that in?
It's a shared ownership. The driveway is in the title of all properties, as is the private sewer.
Okay. I'm also having a little difficulty, I think, what you said, Mr. Burgess, with regard to overshadowing. The structure is to the north of the existing property number 3. Is it not?
Shall I explain my point?
Sorry?
Can I explain my point about overshadowing and loss of sunlight?
If you would, please, yeah.
So as Marge Ballinger explained, we have a patio area on the boundary with number 3, with Kevin's house. Because of the orientation of our north-facing garden, the sun, the late evening sun, that's the only area in our garden where we get sun on that patio. So at 6 o'clock in the summer, the rest of our garden is in shade, and that was an existing situation. However, it's now been worsened by the installation of this building, because we now have the building above the fence, and so we lose even more sunlight in that position, and we've probably lost at least an hour a day of sunlight when we sit out. So it ruins events in our garden with our family. When we have a barbecue, we're suddenly in shade, and that's the issue I'm raising, is that this building is taking sunlight from our patio.
Could I also add that if you're relying on the design drawings provided by the applicant, that the sun positions diagram is misleading. It's positioned over number 2 Linden Close. It should be positioned over Mr. Burgess's property. I would have thought that's a point worth making, that if you're trying to rely on that information you've been provided, it's I'd suggest unreliable.
And can I just add that we are not opposed in principle to this garden building, and I have commissioned at my own expense an architect to produce an alternative design where this could be repositioned in the main garden, provide the same facilities and services the residents require, but in a more neighbourly and appropriate place. And that was accompanied my most recent representations, and the planning officer has it if you want to see where it could go.
In fact, slide number 2, are you back to slide number 1 there? Slide number 2, which is that.
We've seen its
Okay.
proposed alternative position and seen the response. Thank you very much indeed, gentlemen. I don't think, oh, Councillor Laymin.
Thank you. Just a quick question. Did they consult with you at all before they commenced build?
No, they didn't. There was no contact with us at all. They just started building one day.
Yeah, we are quite surprised. I mean, when you live on a small private drive on a cul-de-sac, you know, neighbours get on with each other, and so up until that point, there's been never been a problem. So, you know, this is not a neighbour on neighbour long-term dispute. This is just related to this particular issue.
Thank you very much, Councillor Lee.
Yeah, Mr. Joyce, obviously you picked up on the drainage, and I understand how it's calculated. I just wondered what your view was on having a green roof on that building. Have you looked at that and what that might mean in terms of reduction, which might appease your concern?
So having a what roof?
A green roof.
So what is it? I'm not familiar with the green roof.
Green roof has a light level.
Sadly, Councillor Lee, we have to deal with the application that is in front of us, and not.
Okay.
No, I'm afraid.
All right, thank you.
Councillor Reid, you haven't finished. I do apologise. Please carry on.
Good Chair. It's just going back to this shadowing. I'm looking at page 77 of our report, and also on page 68, which clearly shows your patio in shade all the time.
That's not the case. We do have sun all afternoon on that patio, and in midsummer, probably from 10:30 in the morning. So that is not the case. Our main gripe and objection is that we're losing evening sun. And if you cross-reference to the correspondence I sent you on Sunday. My letter shows the impact of that. My wife is sitting on our garden sofa and she's in shade, and the shade is approaching us.
Thank you, Chair.
Thank you, Councillor Reid. Thank you. Any more questions of clarification? Thank you very much, gentlemen. You may return to your seats. Thank you for coming along today. Since there's no other public speaking, Mrs. Ballinger, do you have any other comments to add before we go to questions?
Yes, I do, Chair. Thank you. I just want to explain why some of the questions haven't been answered through to the neighbors as appropriately as I was relying on the drainage engineer's consultee to come back to us. My understanding his out of office was on until the 9th. So unfortunately, I did receive the feedback last week and I didn't want to publicize it until the reports were already in Democratic Services. So I made Monday the day to publicize this before the committee to make that part of the update sheet. There is some private matters between the dwellings. So my job is to focus on what is relevant within the planning and material to this planning application. On an outbuilding of this size and modest scale, normally we would not consult with our drainage engineer, but due to the objections raised, I thought it was sufficient and the feedback has been provided. Also, I just wanted to comment on the pictures of the flooding and the shadowing. You just have to remember as a planning officer, that might have been something that occurred on one particular day or one particular time or event. But again, overall, this has been a very wet summer. Consideration on that day in particular has been considered within this proposal, hence why the surface water drainage system seemed to be appropriate response to removing any potential future impacts to neighboring amenities. Thank you.
Thank you. Members, questions to our officer, Councillor Lee.
Yes, if I may just pick up on my previous comments about green roof, is there a way to condition the type of style of roof which would then reduce surf runoff and water ingress into the drains?
Well, suggesting alternative designs, we'd have to have we'd have to first prove that this would be a requirement of the application, I believe. And although the roof is sloping in order to mitigate the drainage to where it needs to go, I'm not convinced a green roof with this small of a development would mitigate any of the drainage, hence why the drainage system would be the preferred matter. And we confirmed this yesterday with the drainage engineer. And as far as the condition being legal or not legal, we do, in material planning terms, the condition is considered necessary, relevant, and also enforceable. So that's, again, the private matter between the owners is something that I have to not consider within this planning application, but what this building in this position in the material planning considerations are what we are looking at.
And if I may, I presume the same would apply to the what we've heard may be an overbearing or shadowing issue in terms of how you drop the building into the ground, which then creates drainage issues. But it would be a workaround that way, I guess. But what powers do we have in terms of trying to ameliorate the situation in that respect?
As per my report, I don't believe there is a detrimental harm demonstrated by overshadowing. The building is less than a meter over the fence line and pushed back away from the fence. If it were a two-story extension or anything extremely large that maybe overtook the entire garden in an overbearing aspect, that would be something we would want to mitigate. But in this case, the building is not at that size.
Councillor Williams.
I was just wondering if there could be sort of further details given on why the permitted development rights were removed initially, sort of further to expand on that really. Was there any specifics or reasons behind why the permitted development rights were removed?
Yes, I've double checked the reasons, and granted it was 1987 and they would like to remove a lot of permitted development rights. It is for structures only. It does specifically say that, and it says to ensure the satisfactory appearance of a building. So although, yes, I agree with some of Mr. Burgess's comments about the buildings are positioned in a way that are appropriate for the size of the development. It doesn't dissuade us from having to put forward other alternative permitted development. And hence, this is why the building was started to build. They lowered it thinking they had permitted development rights. And that's been made clear to me on the site visit. When they discovered that they don't have those rights, that's when the application came forward.
Of course, the removal of permitted development rights doesn't mean never any development. It just means it has to go through the planning process to ensure that it's not overbearing and so on. And all these issues are covered. Right. I've got a few questions, if I may, and then I'll come to you, Councillor Reid, Councillor Lamey, in a moment. So the area behind the proposed building, is that still paved, or is that has that paving been taken up? It wasn't clear from the photographs. And if the paving has not been taken up, could we condition it so that there is clear drainage area there for a soakaway area that would be new to this area because it's been paved in the past?
Given the location to the fence and the objections raised from the neighbors, I believe in our discussions with the drainage engineer yesterday, the surface water drainage system is probably best suited than having some sort of soakaway position between the building and the fence of the neighbors.
Okay, so what about, please excuse me, you've had your opportunity to speak, and I heard the point about concrete. Thank you very much, which is why I'm asking our officer what the situation is exactly. But thank you. Please don't call out from the back. Right. I have Councillor Laming and then Councillor Reid with questions.
On the patio, we've heard that it hasn't got any permeability at all. Now, I would have thought we would have insisted on permeability on any patio that goes down or any driveway. Could you just make a comment on that, please?
The patio can be built under permitted development, so this application is just for the outbuilding.
But shouldn't it have been permeable according to our standards?
I think that's outside of this planning application, the hard standing permeability, because we're considering the outbuilding only.
Councillor Reid.
Thank you, Chair. Reference has been made to downpipes, but I cannot see on any of the drawings any guttering. Presumably it's internal guttering.
The building is not finished.
Sorry.
The building has not been finished. It's works that stopped.
Will it have external guttering?
There is a condition in place, condition 2, that specifies how the drainage will be connected into the existing surface water drainage system.
Thank you.
Councillor Lee.
And as the ward councillor, I'm very aware from my time talking to the other residents that this area is notorious for surface drainage issues. And I just wonder whether the case officer has picked up on any of those and whether we're really confident. I don't really want to question the engineer's position, but frankly, you know, from what I hear from other properties, we haven't quite got the surface drainage issues right. So we must endeavour to obviously do that. So I wonder if the case officer has any other information on that.
Thank you. Yes, I do. That's why being in flood zone 1, again, with a building of this size, normally we wouldn't go into this much detail about the drainage of surface water because the displacement is not considered to something we would go that far to obtain the details. However, because it is in flood zone 1 and the Winchester's engineer had no concerns with the fluvial flooding, I did go to the Environment Agency website to see if this is an area of concern. And although I think it notified Forest Road and further south of the area, but within the close itself, this isn't an area, and those are updated, I don't know, weekly, I believe. Those are constantly looked at for the areas of concern.
Councillor Gordon-Smith.
Could we condition putting in a big rain butt?
300 litre.
That could be considered, but the fact that there is an existing surface water drainage system that the house uses, and it's not going to envelop more impact to creating new drainage lines out to the street or anything, that's all connected. It seemed inappropriate for me to request that if they have an existing system they want to access into. But I guess I'm seeking further advice. I don't think we can amend the condition at this stage unless we want to add an informative, perhaps, to consider.
Thank you, Mrs. Ballinger. I agreed with Councillor Gordon-Smith, and I was going to propose that myself, that we suggest we put in a water butt. That would take away the drainage issue entirely. My question is, how much I don't really understand why there's so much concern about extra water coming from the site. There won't be any more rain falling on this particular area, will there? The building is on an area that was already paved. So can you explain to me the concerns?
I do not have any concerns, but I was trying to address the neighbors' objections to the drainage and the potential cause of flooding.
Councillor Small.
Thank you. Yeah, this isn't about drainage, but just looking at the plans, it wasn't straight away obvious, but looking at photograph 10, I'm concerned about this side window. It looks like it peers directly into property 4. I know obviously it's an office. I don't know whether somebody stood up in there. Is
I
that?
believe that is conditioned to be obscured.
Oh, okay. Thank you.
Am I right, Mrs. Ballinger?
Yes, it is. I'm just double checking the condition is within 3 months, but I'm guaranteed that it will happen before then because it's so close to the neighborhood property. There's a mutual privacy protection we need to encourage.
Are there any more questions, members? So, debate. Councillor Reid.
Thank you, Chair. I'm still having problems with the overshadowing, and I've been given really no evidence to show that it overshadows where it's being said it is overshadowing. With regard to views under English law, we do not have a right to a view. We do have a right to light, but then that is quite controlled. Most continental countries have a right to a view. We don't. The removal of permitted development rights, all one has to do really is look at the total site of 7 dwellings. And yeah, it's obvious why permitted development was removed, because everything is so congested together that another structure there, no matter how small or large, is going to have an effect on somebody else. With regards to reciting, we're all aware that if we was to recite it, then that would require another application. So based on the fact what I've heard today, I'm finding it extremely difficult to find a planning reason not to go along with the officer's recommendation.
Thank you, Councillor Reid. Other members? Okay, so let's go to the vote then. Can I see all those in favour of the officer recommendation to approve this application? That's all, members?
Yes.
Thank you very much. So that application is permitted. And that's the end of our items for discussion this morning. We next go to a review of the planning appeals. Members of the public, you are very welcome to leave now if you would like to, but we will move on to the end of our agendas, which is the latest report from our officers. Okay, let's move on to this next item. And I'll just ask Lorna Hutchings to run through the appeals results. Thank you.
Okay, thanks, Chair. So I'll start off on page 83. Okay, and looking at paragraph 11.1, just in terms of the performance data on this is all appeals. We're at 22%. This is in this quarter allowed and 78% dismissed. So that's well within our KPIs. Year to date is pretty much the same, around 79. So numbers, that accounts to 2 allowed and 7 dismissed. So moving on, that's all appeals, and we're at 100% on enforcement still, and slightly less on development management. So the first item is the coppice adjacent to Sunbank in Durley Road. This is quite a significant problem down here of deforestation. On that site at the moment, it's just an interesting fact that the Forestry Commission has served a notice to restock, as that was something we were looking at with the trees as well. But that was for 2 holiday lets, and the inspector very clearly found that there was significant and permanent altered character. That was because of the loss of the trees and the visible nature of the site. So that was a very good win on that one, because that was very inappropriate, like intrusion in the countryside with significant environmental harm. The next one is a lawful development certificate. I wouldn't normally report on those. We didn't win the appeal, but really it looked like we'd resolved a lot of matters through the process anyway. There was lots of discussion on that about whether the structure as a mobile home was a building or caravan, which is something that occupies quite a lot of our time in enforcement. Okay, so moving on.
Take questions on these.
I think we let Mrs. Hutchins go through them all, and then we'll take questions at the end. Thank you.
Okay. We have 2 appeals now on the same site listed building and otherwise, and there was heritage issues with a big gable feature on an extended part of that property, which was found to be very dominating in its mass and its bulk beyond the roof plane. So that is proving once again that there's very high weight on listed building and heritage issues, and no public benefit was found to outweigh that. So we move on to Waltham Chase area. We've got a property, Highfield House, where they were looking to demolish and put up a couple of flats. The inspector didn't agree with us with the character issues. The site was quite tight, but did very much come down on the living conditions of the neighbours, and found that it was to be afforded great weight because there was a real significant harm in terms of sort of loss of amenity there. So that would be a good one to review in terms of when we're looking at amenity, how the inspectorate would do that, because it's quite a high level for refusal. We've got the next one at the Alpines, which was in the local gap, which we refused because of its impact there, and in that area. So that was dismissed, although they hadn't made specific mention of the local gap area, and I'm finding inspectors aren't putting enough importance on it. So that's a bit of a trend, I think, that we need to sort of look into. And then finally, we've got a couple of dwellings on Shill Heath, which I think was a supported refusal for MCRA 3. And then lastly, we've got the paddock in Legion Lane in Kingsworthy, where we've the appeal was allowed, and that was a prior approval. So that was quite an interesting one, the additional story, which is a new PD right. So it's again, it's new territory. The inspector obviously found in favour, and again, it's because it's a permitted development regime. It's very permissive by its nature. And then lastly, we've got the gates on Chilbolton Avenue, which we'd won that appeal as well, with the impact there. So that concludes that. So if there's any specific questions, I can get the appeal statement up and have a bit more detailed look at that.
So, Councillor Reid, you have a question.
Yes, if I may, Chair, it's on number 2, which is Midhurst Lands Farm. Could we please explain the reasons why we didn't win that appeal? Please, it's in the papers.
More sort of complexities of legal than it is planning really, and so I thought Dan might be able to explain that one.
So stationing of a caravan is a use of a land. So by stationing and positioning a caravan for residential purposes, it's just simply bringing it onto the land and then living in it. It's the use, because it's a temporary structure. It's not affixed to the ground. It doesn't have a form of, shall we say, permanence is the best way to put it. I think in this particular case, what the inspector done was essentially made a finding of fact. So in this particular case, the inspector took a different view to the council and held that this was a particular, was it a permanent dwelling? So it had a skirt, it was fixed, it was ensconced into the ground. So it took on a building in that sense. That's important for when it becomes for certificates of lawfulness, because as some of you are aware, there's a 10-year rule and 4-year rule. A change of use is ordinarily 10 years, apologies, whereas a building is 4 years. So it's important for an inspector to make findings of fact so that he or she applies the right legal test. And it was just in this particular case, the finding of fact went against the council, and therefore the immunity period changes as a result.
Thank you. Is it not true, though, that enforcement took no action over the period of time? And this is the part of the reason why the judge or the judgment was made.
It was ultimately found to be immune, and that's because the burden of proof is on the applicant to prove it. We felt that there was proof against that, but it looked like there was lots of matters that enforcement were kind of resolving through that lawful development process. I think there's a phrase that the inspector quotes saying there isn't much of a job left for him to do on this particular one, because of the sort of technicalities of those matters.
But in the report, it states that the floor had rotted. It was immediately set onto concrete. The wheels were removed. And even when the inspector went to visit it, they cut off the towing hitch just prior to his visit, which beggars belief. But more to the point, that is now a site that can be redeveloped on its footprint, not a terribly large footprint, I must admit. However, in September of last year, I drew the attention to enforcement to another unit that had now been situated on the land. And I actually only heard last night, it's a double unit. It's got a driveway to it, it's got gas, it's got all the fittings, it's got a septic tank. And I've been told by the enforcement officer that no action will be taken. I want to know why no action has been taken on something that is totally illegal. There are no checks on its installation whatsoever. What action is enforcement going to do? Because no action is not the right action, in my view.
Agreed. That's something I think I need to take back to the enforcement workings of that team, because that's a bit of a review process. And there's a lot more to it that I don't think is really.
No, if I could ask for that to be taken offline, because it's not actually this appeal, although it's very directly related to it. And I understand that, Councillor Reid, but I think the point has been made and that will be looked into. Councillor Laming.
Just a point of clarity. The 4-year rule, I thought had been blown out of the water after the Surrey house.
Sorry, Chair, I didn't hear what you said there.
Council, I'm not here to obviously give generic legal advice. We're responding to the actual appeal paper, but I can talk to you offline. It's probably not the time for the committee or anyone to sit here and talk about legal principles of the 4-year tenure rule.
We've covered that in the earlier training. So we'll do annual enforcement training.
Councillor Lee.
Not quite on topic, but a suggestion. Is it possible to have some sort of table covering enforcement in terms of progress? You know, red orange, green, and perhaps we pick up on those that are slowing, are in slow gestation of solution.
Chair, we need to take this really back to the office and the work of my management of the team and how we're not currently looking at, shortly we've got a meeting for local enforcement plan review anyway, so we can take it there.
Thank you, members. I think that concludes today's meeting. Thank you for your time and see you next month. Thank you.